focus on some of the provisions or the kind of benefits that young people have that might be most relevant to supporting them in getting to higher education or any post-secondary, whether it be training, and help in supporting that, because we are making sure they maximize every opportunity, every benefit. And the first is just knowing that kids have a right to stay in the child welfare system until 21. That's the law in Pennsylvania. And what I think is important to know about that is there are certain criteria young people have to meet. They can be going to college, but they can be working, and they can also just be receiving services with their independent living program or something that Tabor's providing in terms of life skills. So our law is really broad on what you need to do to stay in the child welfare system. And I know often if there's people around the room, maybe that's not the reality you see with some of your youth. You might see that they're being pushed out. And that is where we do want you to contact us, where you're seeing that things aren't going as you're being told they should, because we do believe that we worked really hard to make this law very broad, but we know there's still a lot of challenges with practice, and it is easier for the system to close a case than work on a challenging one, but we're really committed to working with all of you and with young people to figure out what does it take to succeed and have as many youth, if they want the support, to stay and problem solve and figure out how to make that possible. So do let us know if there's any concerns about that, but it should be pretty broad, and there shouldn't be that many kids who want to stay that should be pushed out. That's really the status of the law in Pennsylvania. It should be hard. We can't force youth into it, but if they want to stay and they're connected in some way to services, they should be able to stay. And the other thing that's also important to remember is that we should have a system where our services and our supports for young people change when they turn 18 to 21. It should actually change before as they get older, but certainly the flexibility that we have to serve them, to have them go away to college and live in the dorms, to have them stay here and go to college, to have them stay here and work, that there's a whole array of living arrangements. So again, I just say that to let you know, if you're hearing someone say, oh, well, you're going away to college, so we gotta close your case. That's not the way it should be. Until 21, the goal is to support youth in their transition to adulthood. If they're doing something productive, if they're staying on course, or even if they're having challenges, we should be able to support them in the child welfare system and provide those services. The law only allows the court to have jurisdiction until 21. It is definitely the case that you see courts, particularly in Philadelphia, extending jurisdiction past 21 in particularly very challenging cases. So I would say the norm is really 21 and the law says 21, but in practice you do see the juvenile court saying, and we think this is right, and it's usually in cases where there hasn't been appropriate planning. It might be a youth who's waiting for a program in another system. So yeah, I mean, I think the kinds of things that we really focus on is before the case closes, there should be a really solid, viable, what we call transition plan or discharge plan. And if there isn't, the court shouldn't close that case. Now, the law does say 21, but there is some flexibility. Ideally, though, we are doing what we need. The system is working with the youth so that can happen. Of course, we all know in reality, the hard stop should more be like 24 or 26. We don't have a law that does that yet, so I'm not saying I think 21 is when everyone should be ready. I think we know from the brain research, from reality, from the economy, 21 isn't necessarily when everyone's an adult and on their own. But that in our legal system in terms of the child welfare system is kind of our hard stop. But definitely we have seen cases, and you guys probably have too, where the court says, no, I'm not letting this happen. But for that to happen, there has to be advocacy. Someone has to ask for that to happen, and frankly, like just raise a stink about it, because it's not the norm. But I do think like one of the things, again, we really focus with people is if you're working with a young person and it doesn't look like anyone's really planning for them, those are real big red flags to really start getting people together. The other thing just to note, we do have the ability to have youth re-enter into foster care. The word in the law is resumption of jurisdiction because it's supposed to communicate it's not a new case. You don't have to do a new dependency petition. You don't have to find that there's been a new kind of case of abuse and neglect. You're just picking up where you left off. But we call it re-entry because it's just allowing you between 18 and 21 to come back into the system. And that's a really great portion of our law that we think should provide more of a safety net and more of what young people in their own, who are raised in their own families have of being able to come back. We all do that. We come back home for help. And to allow that to happen in the law was a really big, I think, a positive improvement. Transition to adulthood services, but youth are, under the law, supposed to get those types of services, and budgeting, education support, housing support, all those things now can begin at 14, and right now they end at 21. Right now, they're currently being provided until 21. Under the federal budget, a lot of things were rolled into the federal budget, which were actually good. That was called the Family First Act. Did not pass as the Family First Act, but its core provisions were passed into the budget, the federal budget that was just passed in 2018, and in February. And a lot of things are really good, and probably a lot of people in child welfare around the table are going to be grappling with them. They're going to help reduce use of group care. They're going to allow to use more federal money for prevention services. But one of the things that's really important to older youth is that what it did say is that we can provide those transition to adulthood services until 23 now.
Wow.
Extending the age, and it also said, we'll talk about the education and training vouchers in a second, but that you can use them until a young person is age 26. So we are seeing that it takes more time. That transition for most people in the general population is about 24 to 26 of when you kind of are establishing your own family, your own home, when you tend to establish your career, 24 or 26. So we're starting to align in the law more of these programs with 24 or 26. We're not there yet at all, but this was one, I think, important improvement. I say if you go to AIC today, they're not equipped yet to do intake, I think, for someone until 23. I'm not sure, but this is very new.
Yeah,
so the law was
still
effective.
21
Yeah.
right now. Yeah.
But hopefully we'll see that soon, and that capacity. And I think again, everyone is really happy about that. The challenge is that they expanded the age, which is good. They didn't give states more money. So they are saying, we want you, and I mean, again, I still think it's a positive in the sense that it's starting to shape the conversation that the transition to adulthood is more mid-20s than 18 or 21. And I get it's not good that states weren't given more money, but definitely it's starting to frame that conversation. So then maybe we can do more state advocacy to say, state funds or city council, can you fill in that gap if we find that there's a lot of 22-year-olds who are coming and it's hard to serve them. So I think it lays a good groundwork for what we're trying to do, but no, it would be good if there was more money. This transition to adulthood services, independent living services, I think it has, one of the things that's positive that it will do is that we haven't really looked at kind of how we're using that money and different ways to use it. So I do think that it's a good opportunity for people to talk about this pot of funds, these Chafee funds, how are states using them, what are the outcomes. There's really not much collection of outcomes. Right. So I do think, I'm hoping that it's an opportunity not to overstretch people, but to have people think about what's the best way to use these funds. One of the key ways that the funds are used are things for life skills classes. They're also used for kids after they've aged out, for housing, which is a really important service. And I think there are some questions of, should we be using more of our money for that or less? So I'm hoping this will more be a conversation about like where providers, people who are doing the services can say, I propose a different way to do this, or I prioritize different services. So I think I'm hoping people will see it as an opportunity. I know that fear of being over capacity, but I think this might be an area of funding and service delivery where maybe there is more flexibility and opportunity for providers and also youth to tell us, you know,
Yes.
what they want.
Yes.
So hopefully, and more to come. I mean, really, this was put into law in February. This was the only provision that was effective immediately. The smallest portion of the Family First Act, the more dramatic things are going to be the push to reduce group care, restriction of funding, and the real great opportunity of now being able to use more federal funds for prevention. Because I think everyone's wanted that the incentive structure is such that you get the federal money when you remove kids, and it doesn't make sense. You should be able to support that child in the home, and this is going to move some of that money to those efforts, and I think that's going to be really good for expansion of family preservation, and for me, I'd love for more people to look at what does family preservation look like when it's a teenager, what expertise do we need for that, and being able to keep more teens in their homes or young adults and getting them back in the home. So, and then the other age that it pushed out is, so education and training vouchers are the federal benefit that's part of the Chafee Act that gives youth up to $5,000, although it's reduced a little just based on the numbers of kids who are eligible. I think it might be 4,000 in Pennsylvania right now. For post-secondary education or training, that age is pushed out to 26. And I think that's just really important because a lot of kids, it takes more time than, right now it's 21 or 23 if you're still getting it at 21. So I do think that's a really promising thing for efforts that really want to focus on, completion of post-secondary programs. So I do think that is a pretty exciting benefit to have. The other thing that we just wanted to mention, and it's not really specific to older youth, but one of the things that we do see in terms of kids accessing higher education and training is just the ease with which they can access financial aid. And we do see, even though a lot of young people in foster care are eligible for the maximum amount of federal aid, often don't get it or experience challenges in accessing because the FAFSA, the federal application, is so complicated. And that's where, I think the AIC is such a great help, Mr. Brooks and his colleague Allie, in helping young people make sure they understand and can navigate the financial aid forms, but will know that youth are eligible, because to be independent, to be in the category of independent student, you are just have to show you were in foster care or reward of the court. So some youth in the juvenile justice will fit under this category. And why that's important is that's what allows them to be categorized as someone who only their income matters and not their parents. Because often the other thing that holds kids up is if they don't fit into that, or they don't, usually they do, but they make a mistake and it looks like that they are a dependent of someone. Then they ask for the financial information of the parent, and they don't have it, and so then they get frustrated, and so they don't kind of hit that point where they realize you didn't even need to be in this category, you need to be in the independent category. So that understanding that all youth who have been in foster care at age 13 or older should be independent, that kind of being able to respond to that red flag. If a young person is telling you, well, I can't get my parents' tax information or their employment, that there should be the, wait, so there must have been some problem with how you filled out this form, let's step back. Because the research that I think they did in California was really showing high numbers of kids that they knew they were doing kind of a data match between who kind of successfully made it through the FAFSA and was got financial aid versus the child welfare population and who was interested in going to school. And it was clear that kids who were eligible were not accessing financial aid. And I know we have the same problem here. And so figuring out, because it is really key that kids have the financial assistance to be able to go to school and not take out loans. The other thing we see whenever a young person tells me they're taking out a loan, it is a step back. Why would that ever happen? And I'm sure there are scenarios that we've all worked with where it's possible, but it should be so rare. We do want youth to have the whole range of schools, but that some of the private schools do have need-based aid. So really just trying to ask, like, if you are taking out a loan, what is the circumstances that would lead to that? And there will be some where you're like, okay, if this is what you want to do, yes, but probably, I don't know, 90% it was because of something happening, that either not accessing assistance, not understanding, miscategorizing something. And I think it's just important because usually, you know, as lawyers, we get different types of calls than you get. We usually get the call of the kid who now is having, you know, a debt collected from a loan for like a technical school. So those are the things where we just want to make sure that, you know, people know what are the ways you think CARE can access financial assistance, help them do it. And
one thing I wanted to mention too, if I can, about some of these forms of support is just a point of clarification too. Those last three, Pell Grant, the Opportunity Grant, State Grant, all those are, many of you probably know this, but all those are sort of decided on based on the information from the FAFSA. The CHAPE is not. Actually access their CHAPE funds. So because it is a separate process and actually it comes out later, the CHAPE application doesn't actually come out until mid-April. So by that time, a lot of students, especially those in their senior year of high school, you know, that's their first time applying, a lot of them think they're done by then. You know, they have already committed to a school, they've already hopefully filled out their FAFSA and all those other things, and so, you know, the CHAPE grant is sort of the last thing on their mind. It's not well advertised also, so I mean the application stays open until the end of December. Peak time to apply is around June and July, but because of how that's sort of managed, I guess, and then when it's released, a lot of students don't actually access that, and a lot of students don't know they're eligible for it as well.
Small perks and like supports to incentivize permanency, you know, to say that we know it's expensive to do these things, and I mean, ideally, we'd like it if it wasn't 13, it was much younger, but these are, we have a lot of lines now, 13, 14, and then 16 for some things, but that is one that's important, and you're